Yes, Professor.
Good morning, my lady and my lords. My name is Dan Sarushi. I'm leading counsel for the appellants, and I appear today with Robert Volterra, solicitor advocate, and junior counsel Jihad Mustafa and Stephen Donnelly.
Yes.
And the claimants are represented today by my learned friends Ben Silverstone and Professor Philippa Webb.
Yes.
I have elevated them to the front row, or they have asked if they could be elevated to the front row.
That's entirely appropriate. We're very pleased to see them both there.
I'm grateful, my lady. My lady, you should have had both sides skeletons.
Yes.
And should also have the core bundle, the supplementary bundle, 10 volumes of joint authorities bundles, and a single supplemental joint authorities bundle.
You perhaps won't be surprised to hear that we are slightly surprised to see quite so many authorities in the bundles, but no doubt you'll be taking us to them and explaining why we need them all.
Yes, I'm grateful, my lady. And in fact, in order to assist the court, we have produced a very short document containing just the quotations and just the provisions of the European Convention and State Immunity on which I'll be relying to assist the court instead of us having to turn up everything, my lady.
All right. Well, we're working hybridly. Some of us exclusively electronically, some of us partly electronically, but you'll have to give us, please, on both sides, all
of course.
the references.
Yes, of course, my lord.
Thank you.
And, of course, my learned friends have a copy. My lady, so, my lords, this is the appeal of the Kingdom of Bahrain against the order of Mr. Justice Julian Knowles, dated 1st of March 2023, made for the reasons given in his judgment dated 8th of February 2023. It's found in Core Bundle 8, PDF page 89. I don't need to take you there now, but I'll just give you the reference. The appellant's skeleton contains a brief summary of the facts, but let me say, by way of very brief introduction, the respondents claim damages against the Kingdom of Bahrain for an adjustment disorder and the exacerbation of an existing adjustment disorder when they allege they discovered their computers were affected with FinSpy software, which they allege was done by the Kingdom of Bahrain. You see this in the particulars. Once again, I don't need to take you there, but it's at paras 44 and 46 of the particulars, core bundle 11, tab 11, pages 158, 159. Neither of the respondents' computers have ever been inspected by anyone to provide evidence that they were infected with any malware.
Well, you say it's a distinction with the Al Miseria case, but why is that relevant?
Yes.
Why is that relevant? Why is it relevant that the computers have not been inspected?
No, this is just simply by way of background.
Right.
And similarly, they haven't received any emails containing such malware, or at least hasn't been proved. Of course, that's appropriate because we're dealing with state immunity at this stage, so we simply assume the facts. The respondents' total claim is quantified in their schedule of loss is between £4,800 to £6,000. You see this at the supplemental bundle A3, the schedule of loss. So the state subsequently contested jurisdiction on the basis of immunity by its application, dated 28th of September 2021, supplemental bundle page 6. The hearing took place on the 22nd of February 2022, and judgment was handed down just under a year later on the 8th of February 2023. The judge subsequently granted permission to appeal on the 17th of October 2023 on 3 grounds, and you'll see this at the core bundle PDF page 140. My lady, my lords, I'm going to consider with you today, first, why the exception to immunity contained in Section 5 should be construed to exclude from its scope any causal act committed abroad by a foreign state. This is ground 2 of the appeal, but since it concerns construction, I shall deal with it first. Second, why the alleged acts of computer surveillance allegedly carried out by a foreign government official who is physically located abroad should be considered an act occurring abroad and not an act in the UK.
Ground 1.
Ground 1, exactly. Third, given time constraints, I will briefly explain why on ground 3, personal injury for the specific purpose of Section 5 should only include psychiatric injury, where there's a concomitant or related physical injury. And finally, I will address the respondent's argument that if the appeal is allowed and immunity is granted, whether the court would have breached their right of access, the claimant's right of access to the court, and I shall explain why this should be dismissed. So first to the construction.
Professor Sarushi, are you doing the advocacy on all grounds?
Yes, I am.
You are.
First, the State Immunity Act and construction, Section 5. My lady, my lords, there are a few key principles relating to state immunity which provide the broader context for the Act, for the State Immunity Act, and as I shall come on to explain, also provide the context for construction of the Act, and in particular Section 5. I'll state these very briefly by way of overview. First, state immunity is a rule of customary international law, which binds every state in the international community. Second, on state immunity, international law on state immunity delimits the jurisdiction of each state's courts to adjudicate cases involving foreign states. This is of great importance to states generally, so that they know when and in what circumstances their acts will be subject to another state's adjudicative jurisdiction. The English courts have drawn extensively from international materials and indeed from other foreign domestic court decisions, both in terms of considering the content of the rules, general rules of state immunity, but also, as I shall come on to show, when construing specific provisions of the State Immunity Act. A specific application of comity, which underpins both the law on state immunity and the domestic UK Act of State doctrine, requires that respect be afforded to the sovereignty and independence of foreign states, certainly when acting within their own territory. I'll consider these principles very briefly by reference to decided cases. I'll take you first, if I may, to Benkabush. Now, you see, I've included just the quote, so it's not advocacy, it's just the quote and the written document. But
That's very helpful.
Thank you, I'm grateful. Let me give you, of course, you will all be very familiar with this, but the cases, of course, involved employment claims brought by two domestic workers employed, one employed at the Sudanese embassy and the other at the Libyan embassy here in London. And these two joint cases concern the application of the employment exception in Section 4 of the Act, State Immunity Act, and the immunity that Section 16(1)A granted to embassies in the UK. As your lady and lordships will know, 16(1)A granted an absolute immunity to embassies from suit. The Supreme Court held that Sudan and Libya did not enjoy immunity from these claims, since in their capacity as domestic workers, the claimants could not be said to be exercising sovereign or governmental acts on behalf of the state, and so immunity did not apply. Lord Sumption delivered the judgment of the court and traced the evolution from the previous absolute rule of state immunity under international law to the current rule of restrictive immunity, under which a state enjoys not absolute immunity but rather restrictive immunity, depending on this sovereign or private character of the acts.
Yes, Professor, it would help us, I think, if you could just slow down a little bit.
I'm grateful.
We've got a generous timetable. We don't think you'll need 2 days, but just slow down a little bit for us.
I'm grateful for the indication.
Thank you. Thank you. Yes.
So if we turn then to the first quotation, which is actually there, you see on the first page, Lord Sumption said at para 17, and you have all of the corresponding references to the bundle and so on, but I can certainly provide those if it would be helpful. State immunity, paragraph 17, is a mandatory rule of customary international law which defines the limits of a domestic court's jurisdiction. Now, if I can pause there, my lady and my lords, this customary international law rule, the restrictive rule of state immunity, is separate and distinct from various treaties on state immunity, which states have signed up to or ratified. Notably, in our case, the European Convention on State Immunity, I'll refer to it either as ECSI or the Basel Convention, and the 2004 UN Convention on State Immunity. And I'll come on to explain the relevance of these treaties later when construing Section 5. But let's continue.
Sorry, you've lost me. Benkabush, Lord Sumption, paragraph...
It's paragraph 17, the first paragraph there. It says, state immunity is a mandatory rule of customary international law.
And the point you're making, this is background, is it?
Yes.
Right.
That this is setting out the principles which the court then goes on to, as I show you lordships, go on and ladyship, go on to apply when construing specific provisions of the Act. And you see there, Lord Sumption continues a bit further down. It derives on the page, it says, unlike diplomatic immunity, then the next sentence, it derives from the sovereign equality of states, par imparem non habet imperium. In the modern law, the immunity does not extend to acts of a private character. So that's the classic distinction between public and private acts, the restrictive rule. In respect of these, Lord Sumption continues, the state is subject to the territorial jurisdiction of the forum in the same way as any non-state party. In jurisdictional immunities of the state, the ICJ case, the rule occupies an important place in international law and international relations. It derives from the principle of sovereign equality of states, which, as Article 2.1 of the UN Charter makes clear, is one of the fundamental principles of the international legal order. The rule where it applies is that a state may not be pleaded in a domestic court against its will. So that's the general position under international law. Lord Sumption continues at paragraph 18. The International Court of Justice, you'll see that after the indented quote, the International Court of Justice has characterized state immunity as procedural. This is correct, but state immunity is not procedural in the sense that the organization and practices of the courts are procedural. It's procedural in the same sense as that concept has been used in the case law of the European Court of Human Rights.
Thank you. So I think we've read this.
Thank you. I'm grateful. And so if I could just ask you also, please, maybe to read to the end of that paragraph 19.
Thank you. Yes.
So those are the general principles of international law. Now, if I could ask you please to turn up the State Immunity Act, which is at the Authorities Bundle, Volume 1, and it's at PDF page 91, if you're using electronic.
Thank you.
You have it, my lady, my lords?
Said.
Yes, grateful, thank you. So you will, of course, know the structure of the Act. I won't belabor this, but Part 1 of the Act concerns state immunity, while Part 2 concerned with the reciprocal enforcement of judgments. Take you very briefly to the general rule of immunity. You'll see it there at PDF page 93. General immunity. A state is immune from the jurisdiction of the courts of the UK, except as provided in the following provisions of the Act. The importance of this, of course, is reflected in Section 1.2, where the court is required to give effect even if a state doesn't appear. So that's a reflection of the international law approach which I've shown the court. If we can move now to the approach to construction of the State Immunity Act, and in particular Section 5. Now, given the significant number of immunity cases going up on appeal, including to the Supreme Court, we now have specific helpful guidance on how to construe the Act. And my lady, my lords, with respect, the judge was wrong to have focused so heavily on the grammatical meaning of Section 5 when he said in his judgment at paragraph 96, and I'll take you there in some detail in a minute, but he says at 96, it is to be presumed that the grammatical meaning of an enactment is the meaning that was intended by the legislator. He went on to say, 96, that he set out the relevant principles of statutory authority with references to authority contained in his Al-Masariya judgment at para 64 to 70. And the reference for that is Core Bundle, tab 9, page 111. I don't need to take the court there, but the authorities relied on by the judge in Al-Masariya specifically in support then of this operating presumption that the grammatical meaning is the meaning intended by the legislature are the following. Shropshire and Recombe versus Secretary of State for Home Department. That's a first instance decision by Mr. Justice Garnham.
Ms. Garnham, yeah.
Yes. In re S.J. Henderson, a first instance decision of the Insolvency and Companies Court Judge Burton. Jeffrey versus Sawyer. We had a little bit of trouble tracking this down, but it would appear to be a case from Ontario, Canada, a regional case. Maguire versus DPP, a decision of the Irish Supreme Court and the Australian case of Alcan versus Commissioner of Territory. Now, my lady, my lords, I do not go so far as saying that the presumption referred to in these authorities is wrong, or that these cases, so far as they are even English authorities, were wrongly decided. But they are, at the best, in my submission, tangential relevance, given the modern approach to interpretation, repeatedly reaffirmed in recent Supreme Court judgments, including specifically in relation to the State Immunity Act, all of which the learned judge ignored. By contrast to the judge's grammatical approach, if I could take you, please, to the recent, relatively recent 2021 General Dynamics case. And you'll see this on page 2 of the
Yes, we have that.
crib sheet. Thank you.
Thank you.
And the key issue, of course, here before the court concerned the construction and application of Section 12(1), which, as the court will know, provides for service on a foreign state by the Foreign and Commonwealth and Development Office on that state's Ministry of Foreign Affairs in its capital city. 12(1), of course, you'll of course know this, requires that a document be served where it's any writ or other document required to be served or for instituting proceedings against the state. Now, the issues in the case are set out by Lord Lloyd Jones at paragraph 10, page 2261. We don't need to go into them, but there was disagreement in the court on a number of issues, but on the principles of statutory construction, specifically of the State Immunity Act, there was agreement.
So what are we getting out of General Dynamics?
Yes, I'm coming. So this is the way in which the court approached the construction of the State Immunity Act, my lady.
Purposive? No, that was Lord Stephen's dissent.
My lady, I'm sorry.
The headline, is the grammar irrelevant?
My lady, I'm really sorry, but I can't hear. The microphone is a bit far away from you. It's a bit...
Sorry. No, the principle from General Dynamics, what are the principles of construction that you say are relevant?
Yes, I'm coming to the right now. Thank you. So it's paragraph 39, and you'll see that the first paragraph quoted there. A key question, and so this was construction of Section 12. Key question is whether proceedings to enforce fall within the scope of 12A, 12(1). This is to be decided, having regard to the ordinary meaning of the statutory provision, its purpose and its legal context, including considerations of international law and comity. We then go on to paragraphs 58 and 59. Nevertheless, so just the context here, Lord Lloyd Jones rejected the existence of a customary international law rule requiring diplomatic service of documents. And you'll see that at PDF page 1185. But then his lordship went on to say, nevertheless, despite there being no customary rules specifically on point, nevertheless, considerations of international law and comity are in play, and they support the wider reading of Section 12(1). The State Immunity Act is primarily concerned with relations between sovereign states, and as a result, its provisions fall to be considered against the backdrop of established principles of international law. The sovereign equality of states is a fundamental principle of the international legal order, and this is reflected in the rules of international law governing immunity from the jurisdiction of other states. Although the immunity of states is not absolute, this is nevertheless, and I emphasize this, an area of considerable sensitivity. More generally on the elements of construction, there was agreement. So this was the majority judgment given by my Lord Lloyd Jones. Then there was a separate dissenting judgment of Lord Stevens, with whom Lord Briggs agreed. They didn't disagree, however, on construction. You see this at para 131 on the bottom of this page 2. The proper interpretation of Section 12(1) of the State Immunity Act is central to the determination of the issue. Several interpretive principles, but for present purposes, it's sufficient to refer to 3. First, every enactment is to be given a purpose of construction. Benyon Bailey, in construing an enactment, the court should aim to give effect to the legislative purpose. A purpose of construction of an enactment is a construction that interprets the enactment's language so far as possible, in a way which best gives effect to the enactment's purpose. A purpose of construction may accord with a grammatical construction or may require a strained construction.
This is the minority judgment, as you say. Is there anything in the majority judgment which says that a strained construction is acceptable?
No, my lord. And then they go on to quote Quintavalia, where it says, this is Lord Bingham in paragraph 8, you see it in the quote there, every statute other than a pure consolidating statute is, after all, enacted to make some change or address some problem or remove some blemish or effect some improvement in the national life. Of course, you refer to that as the mischief of the statute. That's the court's task within the permissible bounds of interpretation is to give effect to Parliament's purpose. So the controversial provision should be read in the context of the statute as a whole, and the statute as a whole should be read in the historical context of the situation leading to its enactment. So in my submission, my first submission then is that it's directly contradictory to the approach of the judge, who started with a presumption, whatever weight one gives it, that the grammatical approach is to be assumed to be correct, especially when dealing with state immunity. And my Lords, Lord Stevens and Briggs continue at 133, a purpose of construction should promote international comity. 134, domestic law should conform to international law. That's the well-known principle. So if I can take you now to the provision of Section 5 itself.
Yes.
And this is at, I'm grateful, my lady, and this is at Authorities Bundle 1, PDF page 96. State is not immune. Heading, yes, the heading is personal injuries and damage to property. A state is not immune as respects proceedings in respect of, and I'll just paraphrase, personal injury caused by an act in the United Kingdom. Now, my plain construction here is that all causal acts, that is, acts causing the injury in the legal rather than purely factual sense, i.e. remoteness and so on side. So all causal acts have to be committed in the UK to engage the exception. Otherwise, a state remains immune under Section 1. So to the extent that a claimant relies on a causal act committed abroad, then Section 5 is not engaged. Now, let me be clear. I'm not saying...
Your submission is not that it's just to the extent that, it's if. I think your submission is that if the claim relies on any act that's not within the UK,
I'm grateful. Yes,
then
that's...
immunity applies.
Yes, that's right. Yeah. Yes, I'm grateful. And let me be clear. I'm not saying that the causal acts and the injury must occur in the UK for the section to apply. The injury can occur anywhere. Let's consider an example. If a car was, where a car was negligently repaired in the UK by a foreign state's diplomat, and as a result of the negligence, an accident occurred abroad while on holiday in France, causing injury to sea, claimant, it would, on my construction, be possible to take proceedings against the foreign state in the UK, since all of the causal acts occurred here. The injury, of course, occurring in France doesn't affect the application of the provision. Now, let me say, by way of overview, my lady, my lords, I have 5 main points in support of my construction. First, as I shall come on to show you, this is supported by the purpose of Section 5. We've just seen from the Supreme Court the importance of statutory purpose. Well, I'm going to explain the purpose of Section 5, which was to implement Article 11 of the European Convention, EXI. Second, the construction is also supported by the Court of Appeal in the Al-Adsani case. The court stated its inescapable conclusion on construction of Section 5 is that state immunity is afforded, this is the quote, and I'll take you, of course, to the case. State immunity is afforded in respect of acts committed by a foreign state outside this jurisdiction. Third, there's a related point of comity which follows on from Al-Adsani, that given the act of state doctrine in English law which existed at the time of enactment of the State Immunity Act in 1978, it would not, in my submission, have been Parliament's intention to have embodied a personal injury exception in Section 5, which on the judge's construction would lead to a stream of cases against foreign states involving causal acts being committed by those states within their own territories, so long as there was a single causal act in the UK. Fourth, it's also supported by the approach of the personal injury exception contained in the UN Convention on State Immunity, which was drafted by the UN International Law Commission. It's a type of international law reform commission, if you like, whose members are elected by the UN General Assembly. The ILC explained, and I shall come on to show your lady and lordships this, of course, that the UN Convention provision on personal injury was drafted precisely to ensure the exclusion of transfrontier torts and to ensure the exclusion of acts that were committed outside the forum state from the scope of the exception. Fifth, the construction is also supported by the US courts when construing their corresponding state immunity exception in the 1976 Foreign Sovereign Immunity Act. I'll refer to that as the FISA, which was an important precursor to our act. The US courts indeed have specifically excluded extension of their personal injury exception to alleged hacking by foreign states of computers where the computer is located within the US solely on the basis that the causal acts were committed abroad from outside US territory. So in exactly the same type of case we have. And as I shall come on to say, my Lord Justice, Lord Mayles asked the question about strained construction. The US courts have, my Lord, adopted a very strained construction because the location of the act is not specified in the US statute, but nonetheless, the US courts considered it so important and they referred in terms to the EXI, to the European Convention on State Immunity, which they said the US statute was intended to reflect, that they excluded causal acts that were committed abroad. Finally, my lady, my lords, the judge relied on two ex parte decisions that were made as part of the process of obtaining permission to serve out. There is, of course, the 2001 Court of Appeal Practice Direction, which says, of course, that you shouldn't really cite these cases, let alone presumably the implication flows rely on them in a judgment. But leaving that to one side, more substantively, in the cases of Heiser in Iran and Ben Rafael versus Iran, I happen to be counsel who argued both of those ex parte hearings, and I shall come on to explain why the passages cited by the judge in the judgment have been subsequently, in the following case of Heiser in Iran, inter partes judgment, were overruled.
The cause of action in this case is Section 3 harassment, isn't it?
Yes.
Which requires a course of conduct, a course of conduct. Your position is it that any act within that course of conduct being committed outside the jurisdictions means there is no jurisdiction at all here, that immunity applies?
Absolutely right, Marie. Yes. I'm grateful. Now, let me actually remind the court what was the judge's construction of Section 5. And in fact, if we could go to the judgment, which is, as I said, at core bundle, PDF page 112.
Yes.
And you'll ask the court to go to paras 96 and 97. This is the one I referred to earlier, where the judge deploys his grammatical approach to construction. So you'll see there, the judge 96, I start with the statutory language. I set out the relevant principles of statutory construction with references to authority in al-Masariya. That's the first instance decision and the foreign court decisions I mentioned, 64 to 70. It is to be presumed that the grammatical meaning of an enactment is the meaning that was intended by the legislator. He then goes on to say...
I think
You've read it.
I think we've read these paragraphs.
Yes, I'm grateful. Okay, and the key point, of course, is he only requires a single causative act to occur within the jurisdiction. He says a single relevant act more than minimally causative of injury. That's the key phrase. Now, when you examine Section 5 on the basis of the judge's approach to construction, I respectfully submit that Section 5 is not clear and unambiguous. How does the judge's construction deal with the clear statement by the Court of Appeal that I'm coming to, that its inescapable conclusion is that Section 5 is afforded in respect of acts committed by a foreign state outside this jurisdiction? On the judge's approach, what is the causative act? I note that the judge had to deal with this by adding qualification to his approach when he says the single act must be relevant. But how is relevance to be determined? And how does this sit with the objective of the State Immunity Act to provide certainty to member states of the European Convention on State Immunity as to when they could be sued in the territory of other members? On the judge's construction, what if the overwhelming balance of causal acts occur abroad? I note the judge says that the single act has to be minimally causative of injury to engage the exception. But again, how is this to be determined? And how does this sit with the objective of providing certainty to foreign states on when their acts will exceptionally be subject to English court jurisdiction?
Why is there any uncertainty about the judge's construction? If a state comes and does something here, which has legal consequences, it's liable even if it's also done things abroad. I mean, that might be a bad rule, but there's nothing uncertain about it, is there?
Well, my Lord, with respect, I mean, if you think in a situation where, let's say, everything happened, everything except one small part of of a particular chain happened in the UK, it may be that the state doesn't even realise that that is actually part of, the English law approach in terms of, in this case, the Harassment Act. And so because it's a question of where states, my submission is the following, that the rule on all causal acts occurring within the UK provides a much greater degree of certainty and predictability to states than a situation where a single act in the UK that may be very minor compared to everything else as a matter of general practice, but under English law, if it's minimally causal, that's the point. If it's under English law, minimally causal, that's not necessarily an easy thing for a foreign state to ascertain.
But I'm not sure that approach yields the certainty that you're aiming at, given the facts of this case. So when there's hacking from place A into and out of place B, there's a debate to be had about whether what happens in place B involves an act.
Yes, there is. And
so the state may not have the certainty that you crave unless, in addition to the basic rule that you propound, is to be said that an act of that kind is only performed in state A, and not in state B at all.
yes, I'd call that a second, you're right, my lord, that's a second level problem, if you like, given the nature of computer surveillance, which is, as you'll come on to see, as we'll come on to see in great detail, is a relatively new area that's being tested. And you have to remember, and this is in fact something that the UN Convention, the US debates in Parliament and so, in Congress and so on indicate that this provision was originally meant to include basic acts within a state like traffic accidents or where a diplomat went a bit nuts and hit someone or did something like that. It was not. That was the original focus of the provision. Of course, it's been sought to be expanded over time. Let me then, if I may, in fact, examine what exactly are the causal acts that have been pleaded by the claimants in their particulars in this case. And if I could take the court to the core bundle at page 145. So PDF page 1448. PDF page 148, and you'll see there, do we have it?
Yes.
My lady?
Yes.
Yes, I'm grateful. You see there the heading, the unauthorised installation on the SS computer, that's the first claimant's computer, and use of FinSpy, buyer on behalf of the defendant. And the particulars go on to state halfway through paragraph 13, it is properly to be inferred that this infection was carried out, directed, authorised, and or caused by the defendant and or its employees, officials and or agents acting on its behalf, and that from around the 11th September 2011 until a date which is not currently known to the claimants. It goes on to allege the defendant and or its employees, officials and or agents acting on its behalf carried out a number of things that were said to constitute hacking. Now, the position in the particulars are identical, my lady, my lords, in relation to the second respondent. I don't need to take the court there, but it's at PDF page 153 of the core bundle, page number 152. My lady, my lords, presumably if the respondents were to proceed to the merits of their claim, they would be making disclosure requests from the state to try and obtain evidence to make out these claims. But what's striking for us today is that none of these alleged acts by the government of Bahrain, that is, the decision to target the individual respondents, to direct, to authorise, to cause the alleged hacking to occur. These acts being said to have been done by its employees, officials and or agents acting on its behalf. None of these acts are alleged to have occurred in the UK. Indeed, the claimants appear to accept, and they'll correct me in due course if I'm wrong, that all of these causal acts occurred in Bahrain. But on any view, none of them occurred in the UK. So if we can now turn to my first point in support, which is Article 11 of ECSI, the European Convention on State Immunity.
Could I just pause
Yes,
you there?
Of course.
There's quite a lot else in the particulars of claim about what the acts complained of are, and my attention is focused on paragraphs 41 and following. 41 being the place in the particulars of claim where the claimants identify the acts in the UK
Yes.
that they say occurred and which
Yes.
were causative. And then they go on, when they come to the injury, having talked about the various acts that happened as a result of the authorised infection of the computer,
Yes.
they say they attribute the injury to those things and, I would think inevitably, the discovery that those things had happened, which was the sine qua non, if I'm allowed to use Latin, the essential component of the causal chain, yeah?
Yes.
So they are saying there were acts in the UK.
Yes, they are.
And they're saying that those acts are the course of conduct and that the finding out was the last chain in the chain of last link in the chain of causation. At some stage, I'd be interested to know what you say about that last point. As I understand the case, they say we were, no doubt you were trying to, Bahrain, on their case, was aiming to keep all of this secret because that's the nature of spying. But it didn't. because WikiLeaks revealed it to the world and confirmed the suspicions that the claimants had entertained before in about 2014. They found that out in the UK, and I think they're saying one of the acts that caused the damage was the communication to them of the certain knowledge, as they would put it, that they'd been spied on. Does that matter?
My Lords, if I may, I'll come back to that, but my response just off the cuff is that we have to look, of course, at the States Acts, my Lord. And I think your Lordship's analysis, of course, has many components, one of which is the finding out. But I'm not sure well, my submission is that that's not a State Act, my Lord.
So you read section 5 down, do you, so that it's a state is not immune as respects proceedings in respect of personal injury caused by an act or omission in the United Kingdom by the state?
Yes, of course, exactly.
Well, I'm not, of course.
Yes, I'm grateful. That is my submission. So it has to be the States Acts. And so any acts that were taken by the claimants themselves, for example, in the United Kingdom to ascertain the existence or not of their position on their computers is, we say, outside the scope of Section 5. I come then to Article 11, my first point. It's common ground the UK has ratified the XE and is bound as a matter of international law by its obligations. You'll, of course, know there's a strong presumption in favour of interpreting English law in a way which ensures the UK carries out a treaty obligation, is not acting inconsistent with it. I'll take you very briefly, this is so well established, I'll take you very briefly, if I may. It's at the bottom of page 3 of my crib sheet, and you'll see there it says Lord Diplock in Garland versus British Rail. My Lords, even if the obligation to observe the provisions of an article were an obligation assumed by the UK under an ordinary international treaty, and there were no question of the treaty obligation being directly applicable, he continues, it is a principle of construction of UK statutes, now too well established to call for citation of authority, may beg the question why I'm raising it for the court, that the words of a statute passed after the treaty has been signed and dealing with the subject matter of the international obligation of the UK are to be construed if they're reasonably capable of bearing such a meaning as intended to carry out the obligation and not to be inconsistent with it. Now, a key purpose of the State Immunity Act was to implement the European Convention. If I could take you, please, on this issue to the recent 2024 Supreme Court case of Argentum versus South Africa. It's proper, of course, to start the discussion of this case by saying that Mr. Justice Julian Knowles did not have the benefit of this judgment, of course. Facts were very interesting. It's for another day, though. They relate to sunken treasure, silver, during the Second World War. But for our case, it concerns the proper construction of Section 10(4)(a) of the Act relating to actions in rem and whether the silver was in use for commercial purposes at the time it was sunk. Lord Lloyd Jones in the judgment described the development of the common law in the common law, as I've just shown you by reference to Lord Sumption in Benkabush, and he then goes on to say, and this is at, you see there the quote on page 4, paragraph 24, it had become apparent that there was an urgent need for legislation in this field. What was needed was not the incremental development of the common law through judicial decisions, but a new statutory scheme providing detailed and comprehensive rules governing both adjudicative and enforcement jurisdiction in cases involving foreign and Commonwealth states. There was also a commercial need to bring domestic law in the UK into line with the new international reality of restrictive immunity. In this regard, it was highly significant that the United States had given effect to restrictive immunity in the Foreign Sovereign Immunity Act. In addition, the UK wished to become a party to the Brussels Convention and EXI, two conventions which gave effect to the restrictive theory in different fields. these would require implementation into domestic law by legislation.
Would it help if we read these paragraphs?
I'm grateful, my lady. In fact, the key passage is where his lordship goes on to say, but limited those exceptions to those cases, and this is here, he's talking about the exceptions in 2 to 11, limited those cases, all of them except 2, where there was also a sufficient jurisdictional link between the contracting state and the subject matter of the proceedings for the purposes of recognition.
Could you just give me the paragraph number again?
Yes,
26.
27, thank you.
Thank you.
26, 25 and 26. So if we then go on to look at paragraphs 27 and 28 of the judgment, in fact, I don't think those appear on our sheet, but let me take you there. It's at PDF page 124, and this is in the appeal bundle.
Sorry, the judgment below.
No, sorry, this is the Argentum case.
Still in Argentum.
Yes.
In which of the 10 bundles do we find it, please?
Volume 8.
It's a volume 8.
Thank you.
Volume 8, PDF page 124. We have that, my lady, my lords. So you'll see there, paragraph 28, it recites section 1, of course, and then it goes on to say, of key importance for us, the following sections then set out exceptions to immunity in cases of submission to the jurisdiction, and then it says personal injuries and damage to property, and then it continues in 29, and this is really the key passage. The various jurisdictional connecting factors provided for in the XE are generally implemented in all of the exceptions to immunity, with the exception of commercial transactions in 3 and admiralty in 10. Thus, for example, under Section 5, a state is not immune, and then his lordship goes on to repeat the terms of Section 5. So, my lord, my ladies, we have the Supreme Court saying that Section 5 has generally implemented the same jurisdictional connecting factor. I don't want to put this too high, of course. Lord Lloyd Jones does not, of course, say that Section 5 of the Act and Article 11 replicate exactly the same, since it was not at issue in Argentum. But it's still helpful in my submission that the Supreme Court singled out Section 5 as a provision that generally implements the jurisdictional connecting factor provided for in the European Convention. Now, this point attracts greater force when we compare the language of Article 11 of the XE to Section 5, and at the same time compare how the key phrase used in Article 11 as it appears in other XE provisions were enacted into corresponding provisions of the Act. Now, we've produced a comparison table to assist instead of having to flick between various bundles constantly. And this appears at page 21 of the document. If I can take you first to page 22, which contains Article 11. And I'm paraphrasing, but a state, you see there on the left-hand column, a state cannot claim immunity in proceedings which relate to redress for injury to the person if the facts which occasioned the injury occurred in the territory of the state of the forum, and if the author of the injury was present in that territory at the time when those facts occurred. You will recall here my point on construction: all causal acts have to occur in the UK for the exception to be engaged. Now, this construction is supported by the first jurisdictional link element in Article 11. And you'll see it there on the page. If the facts which occasioned the injury occurred in the territory of the forum state. There's no limitation here in terms of only some facts rather. It's a wrong slip of tongue. If some facts occur, or indeed a single fact. So in my submission, that includes all facts. And what's important here is the phrase territory of the state of the forum, which is used throughout the EXI. You'll see the words there that are underlined in Article 11 on the document, the territory of the state of the forum. You will recall that this phrase appears then twice, both in relation to where the facts occur, but also you see it then a reference to when the author of the act was present in that territory. That is the territory of the state of the forum. Now, my lady, my lords, this is a very important point. When the phrase territory of the state of the forum has been incorporated into the act, it has been done in one of two ways. Either it is incorporated into the act by use of the phrase in the United Kingdom, as appears in our section 5, and you'll see that on the right-hand side of the column, corresponding to Article 11, or it is incorporated into the Act by expressly amending the phrase in certain state immunity provisions to provide different language from in the United Kingdom. And it's instructive for us today to consider these provisions.
Well, which ones
Yes,
do it by that way?
You're ahead of me, my lady. I'm coming to that right now.
Right.
So the first is then Article 11, which, as I've shown you, transposes that the phrase into the United Kingdom, in the United Kingdom. The second is Article 9, which is directly below on page 22 of the document. And you see here, this relates to immovable property. You see the phrase there, possession, so it's B, its obligations arising out of its rights, interests.
That's an example of it being done in the same way. When is it done by different language?
Yes,
as you put it?
my lady, if you'll bear with me 1 second, because the submission here is that when you look at immovable property, of course, that can only be in the United Kingdom. I'll give you another example of this. In fact, this is comprehensive, my lady. I'm trying to show you that in every instance where that phrase has been transformed into the State Immunity Act, it occurs in one of these two ways. This is a comprehensive review. So then we have Article 8A of EXI, and you'll see that on the following page, the top of page 23. And this is IP rights in the state of the forum, and that's been reflected in the phrase in the United Kingdom. Once again, if you look at Article 8A, that can only relate to rights or the registration and protection of rights in the United Kingdom. It simply cannot relate to anything outside the territory. Third, if you go down the page, Article 8B and C, it says infringement in the territory of the state of the forum. And you see that again reflected. This is the infringement of copyright rights. And you see that reflected again in the United Kingdom. Once again, it relates to things only happening within the UK. Article 8D is the same.
Is it right that Article 8D does not say in the territory of the
No,
state?
it doesn't, my lady. You're ahead of me. I was about to say it doesn't include the phrase territory because it's actually not related. The name is not really. It's a legal right. So in that respect, it's the territorial aspect is less important. Article 6.1 is the final one, and this is on page 21, the first page of this, which says, you'll see there, And this is about companies and associations having their registered office or principal place of business on the territory of the state of the forum. And that's, of course, in the United Kingdom. And that, of course, once again, relates to an exclusive application related to something in the United Kingdom. Now, this is important in my submission. In every case where the standard phrase, either in the territory of the state of the forum or on the state of the forum, has been incorporated in the State Immunity Act to say in the United Kingdom, in every situation where there's the transformation into that phrase in the United Kingdom, all of those provisions envisage something occurring only in the UK, not abroad. And this strongly militates in favour of my construction. This is further emphasised, and I come now to my lady's very good question, which of course is ahead of me, when we consider those provisions of the Act which expressly amend our standard phrase in the territory of the forum, so as to provide different language from in the United Kingdom. And we only have two examples here. The first is Article 4.1, which is on page 21 of the document. And you'll see there it says, falls to be, so this is a contract, and falls to be discharged, where the contract falls to be discharged in the territory of the state of the forum. Now, you see how that's reflected in section 3.1b of our Act, where it says an obligation of the state which by virtue of the contract falls to be performed wholly or in part in the United Kingdom. The second provision is directly below, Article 5.1, as transposed into section 4.1. You'll see there again related to contract, where the performance is on the territory of the state of the forum. The UK Act is broader, section 4.1. An individual where the contract was made in the UK or the work is to be wholly or partly performed there. Now,
from your perspective, actually, just looking at your very helpful schedule, the bit to put in bold is wholly or partly.
yes, in fact,
Yes.
I just noticed that myself, actually, yes. So thank you. So it should be, that's why I emphasised it orally, yes, wholly or partly in the United Kingdom. And so you see my submission, you see where I'm going, that it's very significant that these two provisions of the Act, when incorporating the standard phrase of XC, that was not specifically amended the language by using performed wholly or partly in the UK. Now, of course, Parliament did not use that. It simply said an act in the UK, which, as I've shown, was only used in respect of scenarios where things happened in the UK, not abroad. So based on
But
this...
it does follow, doesn't it, from what you've shown us, that although you say that generally the State Immunity Act was intended to implement the European Convention, in at least those two examples, Article 4 and Article, whichever one it is,
4.1 and 5.1, yes.
5, the immunity was consciously different
Yes.
from the XE provision.
Yes, my lord. Absolutely. And so...
Not in the case of Section 5, because they used the same technique there as for provisions which were not intended to be different.
That's right, my lord.
And that may explain Lord Lloyd Jones's use of the word generally.
Yes, exactly. And indeed, as Lord Lloyd Jones found in Argentum, there was not the same, Section 10, which was concerned with admiralty proceedings, didn't have a corresponding provision in the European Convention. So there are situations where there is a complete difference, and in fact, even there is the other provision, another part of Section 3, simply which does use the phrase "territory of the state of the forum." The European Convention simply is not reflected at all in Section 3 dealing with contracts. So, my Lord Miles is absolutely right to say that there are situations where the Act did not directly or even indirectly implement or give effect to what was required. But this is not one of those cases.
Well, Section 5 is apparently deliberately not following the wording of Article 11 in the other respect, because it doesn't say anything about the author of the act.
Yes, I'm coming exactly to that point, my lords. But my final submission then, just on this first limb of if the facts which occasioned the injury occurred in the territory of the forum state, this limb by itself provides strong support for the construction of 5, that every causal act must take place in the UK or be committed in the UK. And so, on a purely textual level, it gives effect by translating facts occasioning to what I say are causal acts. Now, the judge ignored the effect of this first jurisdictional limb in Article 11 by adopting only the grammatical approach that we've seen. And he focused only on the omission of Article 11's presence requirement, as my Lord Justice Miles has raised. So let me turn to look at that. We recall Article 11, you see it there, of course, on page 22 that I've taken you to of this document, where it refers to the author of the injury must be present in the territory of the state of the forum when those acts occurred. With respect, the judge was wrong when he says that at paragraph 84 of his judgment that Parliament's omission of the presence requirement in Section 5 could only have been intentional. And so the judge says Parliament plainly chose, and this is the quote, plainly chose not to adopt the Article 11 model. Well, I've already explained why that's wrong on the facts point. But the approach by the judge would have been correct in my submission if the first limb of Article 11 of XE had been expressed in terms of act rather than fact. But it was not, and for the reasons I've said, that makes a difference. In any case, there's an important notes on clauses to consider in relation to the presence requirement. It provides an interpretation by UK government officials, and I put it no higher than that, of the scope and application of Article 11 of XE. The notes on clause...
Moving on to a different point, can I just say while I remember?
Yes, of course.
This is a helpful document, and it would be even more helpful if we could have it electronically, please.
Yes, of course. Of course, we'll arrange for that. Thank you. I'm not sure how simultaneous are things here, Mother. No, but I'm saying if we send it, you may or may not receive it simultaneously, but as long as one doesn't consider that an act in court, then it's fine. In any case, my lords, if we go on to the notes on clauses, these go to the mischief in relation to why Section 5 of the Act was enacted, but it also clarifies a second element of mischief, that Section 5 was seeking specifically to implement the jurisdictional link provided by Article 10 of the Convention of the 1971 Convention on Recognition and Enforcement of Foreign Judgments in Civil Commercial Matters. That's the second convention that Lord...
Right, so just so I can find out, place myself here.
Yes.
We're still on your first point, are we?
No, my lady, I'm grateful. So we've moved away from the first jurisdictional limb of facts occasioning the injury to that have to happen in the territory of the state of forum. Now we're moving to the presence requirement,
Right.
which is the second jurisdictional limbs. And you see that in Article 11 on page 22, where it says, if the author of the injury or damage...
I see it, but
yes.
this is still part of your first point, though.
Yes, it is. Yes, it is.
This is
Yes, it is.
supported by the purpose. of
By
Section
Article 11.
5. Right, okay, by Article 11. Yep.
And so we turn then to look at what the notes on clauses say. It's proper to record, of course, that the judge only had the benefit of the notes on clauses post-judgment. But the judge and my learned friends were sent the notes on clauses some 2 months before permission to appeal was granted.
I mean, there is obviously strong resistance to us being taken to these documents at all. Is everybody happy for us to look at them de bene esse, at least, at this stage?
Yes.
Yes.
I mean, my lady, if it's helpful, I can point you to an authority in support of this. And if I could take you then to Wilson and First County.
No, you're slightly losing us. Don't be distracted by the admissibility point at the moment.
Okay, I'm grateful.
We're talking about Article 11.
Yes,
You're looking at the presence requirement in Article 11, which does not appear in Section 5.
exactly.
And your point now is what?
My point now is let's turn to look at what the notes on clauses say.
Because
Because it demonstrates why my construction is correct, Section 5.
Now, where do we find the notes on clauses?
Yes, I'm grateful. So the notes on clauses, let me take you to that. Is it in the handout? No, I've
it's written on an old typewriter.
Is it in the handout? It's in the document,
They're on the electronic.
page 5.
Takes us back to the days of typewriters.
Yes. Page 5. You'll see it at the top there.
Right, thank
Now there are two versions. There's no difference. I've checked meticulously between the different versions. The first version was draft for the original State Immunity Bill. Refers to Clause 6, which became Section 5 in the Act. The second refers to, was made to the State Immunity Bill at the House of Lords. And so you'll see there, it says, this clause implements, at the top of page 5 of the document, this clause implements Article 11 of EXE as para 47. And if I could ask you just to read.
Yes, certainly. Let us just read that.
Yes.
Sorry, this clause, this is a reference to...
This is a reference to the provision in the bill
That became Section 5.
that became Section 5.
Good. But it can't be right if it was referring to what became Section 5, because it suggests that Section 5 had this presence requirement.
Well, let me take you through. Let me take you through it. So,
Words have not been...
Oh, yes, later on.
It says those
Yes,
words have been
yeah.
omitted because it's hard to imagine circumstances, difficult to imagine circumstances when Clause 5 would apply
Yes.
when the
Thank
person
you.
responsible was
Yes.
outside the UK.
yes, that's exactly right.
Possible.
Yes. So it's exactly the point, my lord. So there's
At all now.
there's 2 points here. The first is you see the emphasis after that it says, provided that it was caused by an act or omission in the territory of the forum and the person who was responsible when the act or omission occurred was in the territory. And then at the end, exactly as my Lord Justice Warby has taken us, these words have not been, this is the presence requirement, have not been repeated in the bill because it is difficult to imagine circumstances when Clause 5 would apply when the person responsible for the act or omission was outside the United Kingdom.
So what's the date of these notes on clauses? 76, 77, something like that?
Yes, well, my learned junior will.
When the limits of imagination about technology were rather narrower than they are now.
Yes. Yes, I'll come to this, to the always speaking point.
Yeah.
Bundle 1. They're very sweet.
So that's especially so in my submission, given the parliamentary draftman understandably collapsed facts and authorship into the more elegant acts. And my submission here then on the notes on clauses is that it makes plain that Parliament did not consider the presence requirement in Article 11 to have any additional practical effect. Precisely because the author of the Act, what it was envisaged, have to be in the territory in order to commit the causal act here. Now, if I may assist the court, I'll move to my second point on Al-Adsani, my second point on, in support of construction. Al-Adsani, I'll take this relatively quickly. Your Lordship's and Lady Chief Justice will know the facts of this case. But in brief, the claimant was a UK national, sought to bring proceedings in the English courts against the government of Kuwait and 3 co-defendants for 2 connected sets of causal acts, alleged acts of torture that were allegedly committed abroad in Kuwait, and a number of connected acts comprising threats alleged to have been made against him by the foreign state once he was back within the UK, which was said to have exacerbated his injuries caused by the initial torture that occurred abroad. If we pick it up in the judgment of Lord Justice Stuart Smith at the bottom of page 538, and you see this on the judge's document, Para 8, page 5, it's at, if my Lord Justice Miles is using that version, it's, I think...
I've got it, thanks.
Oh, you've got it. Thank you, I'm grateful. So page 538, sorry, yes, page 538. So far as the events in Kuwait are concerned, therefore, it is what took place during his detention at the state security prison, which is the foundation of the claim against the first defendant. Then he continues over at 539, goes on to describe the threats that were allegedly directed against the claimant. There were threats of dire consequences if he continued to publicise his case. And this is very important in my submission. The plaintiff's claim is that these anonymous telephone calls have been made by agents of the first defendant and that they hindered his recovery from the post-traumatic stress disorder caused by his experiences in Kuwait, and alternatively have added to his suffering by increasing his stress and anxiety. So in relation then, let me just pause there. In relation to the alleged causal acts in England, these were both causally connected acts. They were causally connected acts to what the state had allegedly done abroad. So the threats had occurred in England, as I'll come on to show you. So those were clearly in England, but it exacerbated the injury caused by acts abroad. And you see this, and Lord Justice Smith goes on, rather, at page 540, to say, despite these being causally connected acts, His Lordship goes on to say at paragraph 540, it is plain that the events in Kuwait do not fall within the exception in Section 5, and the express words of Section 1 provide immunity. First defendant was the state. So, my lord, my ladies, in this case where there were causally connected acts, some alleged to have been committed by the state abroad, some within the UK, Lord Justice Stuart Smith dismissed the application of Section 5 on the sole basis that the acts were committed abroad in relation to the foreign acts.
How did the judge below deal with this authority?
The judge below agreed, my lady, as I shall come on to show you. And you're ahead of me as always. You see then the next paragraph says, I have no doubt, this is Lord Justice Stuart Smith's judgment, I have no doubt the judge was right to hold that the first defendant is entitled to immunity in respect of the acts alleged to have taken place in Kuwait.
I'm being a bit slow here. Was there an issue in this case about whether the threats that took place in this jurisdiction enabled Section 5 to be relied on?
No, there wasn't. No, there wasn't. But
there seems to have been a different argument, which was treated
Article
with
1.
some
Yes.
disdain by Lord Justice Stuart Smith in this paragraph about the law of nations. Yeah.
Oh, yes.
Yes.
There is. And so what the broader context, Al-Azani, is the claimants were making an argument that Article 1 should effectively be read down, so that it should not include acts of torture.
So you have a sort of weak point that comes out of this, that no one thought that might do the job.
It's
but
weak.
Not a strong point, which was that the court held that it wasn't enough.
Yes. And I should come to support. Let me move on to see what the what Lord Justice Ward said on this point. But before I do, if I can just, there's a point here that arises still from Lord Justice Stuart Smith's judgment, and you'll see this at paragraph 544, page 544, and it's at the top of page 6 of the judge's document. And he considers the consequences of a position where foreign acts can be adjudicated on by the English courts. Now, I take your Lordship's point, but it still is of relevance today. A moment's reflection is enough to show that the practical consequences of the plaintiff's submission would be dire. The courts in the United Kingdom are open to all who seek their help, whether British citizens or not. Vast number of people come seeking refuge and asylum, and many of these allege that they've been tortured in the country whence they came. Some of these claims are no doubt justified, others are more doubtful. Of course, that statement was made in relation to acts of torture, but the court will appreciate there's a serious floodgates point that hits home here in relation to the judge's construction on Section 5. And claimants may simply be temporarily in the UK, and if they allege a foreign state has carried out computer surveillance against them, this would be sufficient on the judge's construction to allow them to circumvent immunity. More substantively, if I can take you to the judgment of Lord Justice Ward, and this is the next quote on page 6, and the PDF is...
The allegation would not be enough. They'd have to prove it to a sufficient standard, as the judge held that the claimants here had done.
Yes, at a prima facie basis, yes. At a prima facie basis.
Certainly. But it's not just an allegation. The claimants here obviously went to a certain amount of trouble to get expert evidence and so forth, which they said established what they needed to establish.
I fully take your Lordship's point. There must be prima facie evidence sufficient. But I think the broader point is that it would, as long as that can be fulfilled, it would significantly lead to an increase in claims in this area. If I go to then Lord Justice Ward's quote, which is you'll see there at page 6 of the document, PDF page 285, after quoting Section 5, his Lordship goes on to say, an action for damages for torture is a form of proceeding in respect to personal injury. It's inconceivable that Parliament legislated for the loss of state immunity when the acts causing that person injury are committed in the UK.
Can we just go back to page 544?
Yes.
Because it looks as if the court did deal with the threats in the United Kingdom, and that failed not because they were not within Section 5, but because they had not been sufficiently proved.
Yes, you're right, my lord.
At least a possibility being that if they had been sufficiently proved, they would have been cases which could go to trial without immunity.
My lord, you raise a very important point, because the structure of the judgment is such that the Court of Appeal considered separately the acts occurring abroad from the acts occurring in the UK. And as I've taken the court to Lord Justice Stuart Smith, he dismissed the acts, as I've shown you in that paragraph, solely on the basis that the acts occurred abroad. That's the point, my lord.
Sorry, could you repeat that?
Yes. So the structure of the judgment, of Lord Justice Stuart Smith's judgment, is such that he considered separately the acts that occurred abroad from the acts that occurred in the United Kingdom. And I've shown you the pleading that was done by the claimant in that case, who sought to make a connection, a causal connection, between the threats and the exacerbation of the injury that occurred in relation to the torture that he'd originally sustained, or arguably sustained. And so my point is that Lord Justice Stuart Smith dismissed the acts abroad solely on the basis that they were committed abroad. Whereas he then went on to analyse separately the acts within in the United Kingdom. And as my Lord Justice Miles points out, there was a lack of of those acts sufficiently being proved to be state acts.
But wouldn't it follow that there's no need to consider whether there might be a causal link between them? If they're not sufficiently proved, then the question of causal link between the acts abroad and the threats here doesn't arise.
That's one approach, but the court has in the judgment, Lord Justice Stuart Smith separated out the analysis, my lord.
Yeah.
And we see this also reflected in Lord Justice Ward's judgment, which with whom Lord Justice Buckley agreed. And after quote, and this is the quote on page 6 of the judge's document at paragraph 12, you'll see it says, an action for damages for torture. It goes on to say, unfortunately, so it was talking about Article 1 and the fact that you can't read that down, as I've mentioned, in terms of acts of torture. And Lord Justice Ward goes on to say, unfortunately, the act is as plain as can be. A foreign state enjoys no immunity for acts causing personal injury committed in the UK. And if that is expressly provided for, the conclusion is impossible to escape that state immunity is afforded in respects of acts of torture committed outside this jurisdiction. Now, there's the kind of grammatical point that he refers to acts in the plural, but let's leave that to one side. But my submission here is that there's no equivocation or qualification here that only a single causal act is required in the UK so as to import into Section 5 causal acts committed abroad. My lords, my lady, Chief Justice, this approach to construction is further supported by the academic authorities.
Now, did you make this submission in this detail to the judge below by reference to Al-Azhari?
I took the judge to Al-Azhari, and
I found two references to it, paragraph 95 in the judgment below, and in a different context, or still on this aspect, paragraph 112. Are those the two places where he addresses
yes,
them?
yes. He effectively ignored Al-Azhari. If I could take the court now to Fox and Webb, and you'll see this is, the quote is reproduced on page 6 of the judge's document. This is under the heading, it's the authorities, supplemental authorities bundle 6, tab 6, PDF page 371. And it says there, the jurisdictional requirement, this is under the heading, the exception for torts causing personal injury, Section 5. It's dealing with our Act. The jurisdictional requirement that the act causing damage or injury be committed in the UK bars a remedy being brought for personal injuries inflicted abroad. The decisions in Al-Azhari and Jones establish that where the alleged wrongful act of a foreign state fails to come within the tort exception in Section 5 by reason of its commission abroad, the general principle in Section 1 applies.
What do we get from this?
So this is reaffirming the general approach taken by the court in Al-Azhari, and it then simply academic authority construing it.
I just don't get, at the moment, I don't get anything from any of this. What do I get from this paragraph?
Well, I think it's simply.
I mean, clearly, if you don't fall within the tort exception in Section 5,
Yes,
then, and there are no other exceptions that apply, you're in Section 1.
yes. Okay, my lady, I'll take the hint.
I mean, if I'm wrong, let me know.
No, you're not wrong. I mean, essentially, the point is this is a modern. I think that, one of the allegations that may be made is Al-Azhari was in '96, and this is a modern reassertion of the point.
Right.
And so, if we then move to my third general point on comity in construction, in support of the construction.
So third point, thank you. Yes?
Oh, actually, my learned junior has hopefully pointed out something that is different from the provision. So from Al-Asani. So if you see on the Foxton web, it says there none of the exceptions in the Act was applicable to the plaintiff's allegations. The exception in Section 5 applied only where the acts occasioning personal injuries were committed in the UK, which of course replicates the language of the Article 11 of the EXI. In the plural, yes. Let's move on to my third point on comity. And you'll recall the importance placed on this. If I can please take you to the Venezuela gold case in the Supreme Court. Your lady and lordships will know this case very well. Suffice to say, it concerned a number of issues related to recognition of foreign heads of state and our Act of State doctrine. Lord Lloyd Jones gave the judgment, and at paragraph 135, PDF 1106, you'll see on page 7 of the judge's document, he discusses initially Act of State, but then moves on to consider comity and state immunity. If I could ask your ladyship and lords to please read the first sentence.
Sorry, could you give me the reference, please?
Yes, it's in the judge's document, but the reference is, it's page 7 of the document, para 13, Lord Lloyd Jones.
Yep.
The first sentence.
Yes. Right.
The rule has a sound basis in principle. The rule, i.e. that we don't sit in judgment on the lawfulness or validity of foreign executive acts. And he goes on to say, his lordship goes on to say, it is founded on the respect due to the sovereignty and independence of foreign states and is intended to promote comity in interstate relations. While the same rationale underpins state immunity, the rule is distinct from state immunity and is not required by international law. Now, of course, our present case is dealing with state immunity rather than act of state, but it's important in my submission for us to understand the reach of the principle that underpins the State Immunity Act. And the application of comity in the context of the Act, my application of the comity, and you have my essential submission on this, is that it would be, in my submission, an absurd position for Section 5, for Parliament to have intended Section 5 to create, if you like, a pipeline of cases that as soon as they emerge would be in conflict with the Act of State doctrine. It cannot, in my submission, be the position, my lady and lords. The better construction is that Parliament has not legislated to provide a pipeline of cases resulting in automatic, in some cases, breach of the Act of State doctrine, but that it requires all the causal acts to occur in the territory.
Well, the Act of State doctrine is that we don't sit in judgment on the acts of foreign states within their own territory.
Yes.
But we do sit in judgment on their acts within our territory.
Yes. Yes, that's right, my lord. And that would be fine if my construction is accepted, which is that all causal acts must occur in the UK. But on the judge's construction, where only one single causal act is required to occur here, but that there may be a whole series of causal acts committed abroad, the judge's construction flies in the face of the Act of State doctrine, which I've shown your ladyship and lordship, your lords, is a fundamental principle of comity that underlies both Act of State and the State Immunity doctrine.
One of the features, perhaps, is that when we're dealing with this type of alleged activity, we are not looking at a single act. We're looking at a course of conduct, an alleged course of conduct. And the question really is where we fall in that sort of situation. I mean, what's the closest authority that comes to dealing with the sort of multi-act course of conduct situation that you've shown us so far, or you're going to show us later today?
My lady, I was going to end with this. There is no case This is a novel decision.
So there are two features here, not so new, but still the standout feature of where we were in 1978, digitally, in terms of electronic developments. That's one aspect of it. The other aspect, as you say, is that it's where the balance is to be struck when you don't have a single car accident or a single act. We looked at the very helpful comparison table where you look at a single contractual obligation that could be wholly or partly performed here and elsewhere. But here we're not looking at a single obligation or a single act. We're looking at an alleged course of conduct. And that's the question for us.
And my lady, you're right to ask that question, and my submission is Section 5 imposes a bright line. It imposes a red line between those causal acts that occur within the state, within the UK, and those causal acts that occur abroad. That's the bright line that's imposed.
So the submission in the context of a claim in harassment, where there have to be at least two acts to constitute the cause of action, is that if one of them takes place in the foreign country and the other, assuming there to be only two, or all the others, if there are more than two, take place here, then the doctrine of state immunity and the doctrine of active state all tell us that the state in which one act occurs but none of the others do is immune. The state is immune, notwithstanding that all but one of the causal acts take place here.
Yes, yes, and I'll come on to this issue, but I think let me dispel something right now, which I'm coming to in ground one. There's a very strong submission to be made that computer activity is not an act that as such. It's what the operator or the commander does that is the act.
Yep.
And that actually, there's this Court of Appeal authority, which I'll take you to, which says, Lord Justice Morbeck, which says that actually all a computer program is doing is changing the physical characteristics of the computer. That's not an act, that's the effect of the act.
Is it really right that issues of comity and jurisdiction immunity really should turn on expert evidence as to quite what goes on where in the ether, one bit of metal disc, another bit of wire here? Is that really a sensible outcome?
My lady, I'm getting ahead of myself, but I agree. It should not be, because it should be where the person who is alleged to have committed the act is located. But I'll come on, that's ground one, and I have detailed submissions on that. But it's worth stressing a point here in response to the questions, that state immunity does not mean state impunity, as the judge said in his judgment at paragraph 135. He says, it seems to me that recognising the immunity and impunity of a foreign state to interfere with rights and freedoms enjoyed by those on UK soil on the artificial basis, he says, that not everything happened here would be contrary to the core underpinnings of immunity. Now, as I've shown the court, a core underpinning of immunity in my submission is the sovereign equality of states and customary international law only providing very limited exceptions, such that domestic courts can adjudicate claims against foreign states. And I stress domestic courts here because foreign states, sovereign states, are of course actively engaged in resolving disputes on the international plane, including if a state decides, if it so decides, to use diplomatic protection. Now, my lady, my lords, in my submission, the judge's approach to construction was erroneously influenced by the tragic murder of Mr. Litvinenko in Salisbury. If I take the court to the judgment, this is at paragraph 133. And it's, get the reference for you. It's a core bundle.
One, two, two.
Thank you. I'm grateful you're ahead of me. Thank you. And so it's at paragraph 133, just before the indented quote, where the judge says, if the defendant's submissions in this case were right, Russia would be entitled to immunity for Mr. Litvinenko's murder, despite Sir Robert Owen's conclusions. Well, in fact, if I could just ask the court to read. Thank you. So he ends by saying that would be a perverse outcome. Now, let me start here by addressing this. There's an important distinction to be made between the criminal and civil jurisdiction of the courts, which appears to have been overlooked by the judge. Section 5 in its construction is of no relevance or importance to the UK courts' exercise of criminal jurisdiction over Russia and its agents for the murder of Mr. Litvinenko. Criminal proceedings are expressly carved out from Part 1 of the Act by Section 16(4). I don't need to take your lordships, it's very plain. So it's the common law which exclusively governs the exercise by the courts of its criminal jurisdiction in such a case, and this is important since it means the construction given by the judge to Section 5 is irrelevant to criminal proceedings and irrelevant to what the judge says whether Russia would be entitled to immunity for Mr. Litvinenko's murder in relation to criminal proceedings, at least. Of course, civil proceedings are what we're discussing here. There is, though, the important general point that state immunity exists in international law and has been given by effect by the Act to promote wider interests of justice than just those of the parties to any individual case. And the Litvinenko case does serve to demonstrate, in fact, the broad range of measures that a state whose territorial sovereignty may be affected can take in response to a foreign state's causal acts, which may not otherwise have all occurred on the foreign state's territory. So in this case, for example, the Litvinenko case, there was a criminal prosecution in the United Kingdom of the relevant individuals that was commenced, and when Russia refused to extradite the suspected poisoner, the UK government expelled 4 Russian diplomats from the embassy in London. The UK also launched an internal review of cooperation with Russia.
We need to go into the detail too much.
I'm grateful, my lady, thank you. I would just also say that the European Court held, in terms of court process, the European Court held Russia liable under the ECHR for the poisoning of Mr. Litvinenko and ordered it to pay damages, and you have the case in the skeleton. It's also telling, and this I would just make very briefly the point, that 11 years later, in response to the Russian poisoning of the Skripals, Her Majesty's government at the time coordinated with allied states, and it led to 23 Russian diplomats being expelled here, but importantly, 26 other countries joined together to expel 120 suspected intelligence officers. And so there are a number of things that a state can do if its territorial sovereignty is affected by foreign states' actions in the state. If we continue on to see what the judge said at paragraph 134, and if I could ask your lady and lordships please to read that paragraph 134. It says, I cannot conceive of any reason.
Yes.
Yes, I'm grateful. Thank you. So you see, the judge relies on 2 authorities. He says the exception gives priority to this is the exceptional state immunity to the foreign state sovereignty when the injury is caused by an act on its territory, and he refers to the ICJ case and Belhaj. Now, my submission is that the judge misconstrued both of these authorities. They do not give priority. And I'll show you this by reference to the cases. First, if I could ask you to turn up on page 7 of the judge's document, the ICJ judgment in the jurisdictional immunities case. And you'll see, and once again, if I could spare my ailing voice, ask you to kindly read that.
Of course.
Paragraph 57.
Yes.
Thank you. Just while you're reading it, the point is there's no priority accorded to either principle.
Well, that may just have been a phrase he used.
Yes, but it's important in my submission, my lady, because he relies on this for in support of his construction. Sovereign equality, you see there, it says it's a fundamental principle of the international order. All the ICJ is saying is that you have to view the two principles together.
Yes.
The quote by the judge from Lord Mance's judgment in Belhaj at paragraph 12 indeed supports my construction rather than that of the judges. My lady, despite the length, as you observed, of the authorities bundles, this is Belhaj somehow managed to slip under the radar, given its size. I don't know how that happened. It doesn't appear in the authorities bundle, but presumably because neither side relied on it in the skeletons and subsequently. But we can supply a copy if necessary. But let me, if I may, read out the very short single judgment. And I think it's reproduced, should hopefully be reproduced.
I don't think we need yet another authority. Do you want to just identify what
Yes,
the
of course.
paragraph 12
Yes, of
says?
course. It's paragraph 12, Lord Mance in Belhaj. And the point is, Lord
Paragraph
Mance...
4?
12.
12, yes.
And Lord Mance says the following. He says, the absolute independence of every sovereign authority and the international comity, which induces every sovereign state to respect the independence and dignity of other sovereign states, every other sovereign state, was similarly identified as the basis of state immunity by Brett L.J. It simply does not support the judge's approach. I should say, I didn't read out the whole thing, but Lord Mance reproduced the quote from the ICJ that I've taken you to, and then went on to say that.
I mean, I obviously accept that the judge used the word priority, but where did the notion of priority come into his reasoning as opposed to permits?
Well, because he says that there is a priority that's given to territorial sovereignty over state immunity, he then goes on to say that because there is, and you see this at paragraph 135, my lady, he says towards the end of that passage, it says, it seems to me that recognising the immunity and impunity of a foreign state, he goes on to say, on the artificial basis, would be contrary to the core underpinnings of immunity. And that's what he's saying. He's saying that immunity should always take a back seat, if you like, whenever something happens on the territory of a state.
Well, even the ICJ, in the passage you've referred to, says that immunity may represent a departure from the principle of territorial sovereignty, which, if one wants to play with words, and I suspect it may be not much more than that, rather suggests that territorial sovereignty is the fundamental underlying rule.
Yeah, well, my lord, and exactly after that, you're right to point that out, but exactly after it says immunity may represent a departure from the principle of territorial sovereignty and the jurisdiction which flows from it. But my point is exactly that, as your lordship has started to say, that they are both equal things that one take into account. Neither has priority over the other. That's my submission. So if I can turn now to my fourth point in support of my construction, the UN Convention of 2004. Of course, your lady and lordships will know that while the UN Convention is not in force, the UK has signed but not ratified the convention. So technically, it's not binding as such. But on the role of the UN Convention, I would ask your lordships and Lady Chief Justice, please, to go to Lord Bingham in Jones versus Saudi Arabia on page 7 of the judge's document. And the point is a short one. Lord Bingham quotes Mr. Justice Aikens, as he was then, in AIG Capital, to say, quotes with approval, its existence and adoption by the UN, this is the UN Convention, after the long and careful work of the International Law Commission and the UN Ad Hoc Committee, powerfully demonstrates international thinking on the point. Now, the provision of the UN Convention, which corresponds to Article 11 of EXI and Section 5 of the Act, is Article 12 of the UN Convention. And it provides, and I'll take you to this, please, if I can. It may be most convenient to do this through the appellant skeleton, which is at Core Bundle, tab 4, page 44.
Yeah.
Paragraph 61. Do you have it there?
Yes, we
I'm
have it.
grateful, thank you. So you'll see there the highlighted words. Caused by an act or omission, which is, so this is the personal injury exception. Caused by an act or omission which is alleged to be attributable to the state if the act or omission occurred in whole or in part in the territory of that other state, and if the author was present in that territory at the time of the act or omission. So this similarly has a requirement of the act occurring in whole or in part, different, and I'll come to that in a minute, but also it has the same presence requirement as EXI. Now, on this, if I can take you to the leading Oxford commentary on the UN Convention on State Immunity, which is at Authorities, Volume 10.
And the note at paragraph.
Oh, yes, actually, it is in this helpful document, page 8,
Yes.
my lady. You see there, it says page 8, para 16, page 209, from the Oxford commentary on the UN Convention. Article 12 is the odd one out among the exceptions to a state's immunity from foreign jurisdiction. All the other exceptions reflect at least the non-sovereign character. The exception in Article 12 is justified solely by reference to the place where the impugned act or omission took place, namely in the territory of the forum state. It then goes on to say at the next quote, pages 221, with the exception of the phrase, and in fact, maybe I'll ask you just to read that. Again, it's a rather long paragraph.
And what are we getting from this?
Yes, so the point is that it says, well, there's a number of things. Maybe if you read it first, my lady, and then I'll make my submissions. So, this incorporates the International Law Commission, as I say, which is the body that drafted the convention, and it makes clear that the presence requirement means that in practice all causal acts will have to occur in the territory of the forum state, and that fits the mechanic example that I gave earlier. Finally, in terms of authorities, if I could take you to Fox and Webb, which is also on page 8.
So, sorry,
Yes.
Do you rely on the section which says, the second
condition.
Second condition has been inserted to ensure the exclusion from the application of this article
Yes.
of cases of transboundary injuries or transfrontier torts.
I do, my lady. And I summarise that problem.
What do you say the alleged tort here is?
Well, here it's, of course, I would say it's a transfrontier tort. It involves causal acts that were committed in different countries.
It's not quite the same as chucking a bomb across the border, is it?
No, it's not.
Subject to your point on ground
Yes.
one, of course.
Yes.
But if you were wrong on ground one, then we'd have things going on in state A and things going on in state B, each of which would qualify as acts.
Yes. And in my submission then, we go back to the bright line, al-Adsani, and what occurs within the UK engages the exception. What occurs abroad does not.
A closer analogy might be the shooting across a boundary.
Yes, in
The
fact,
trigger being pulled in state A and the bullet landing, the bullet crossing and causing the damage.
Well, my lady, analytically, there are two things at play here. The first is where the computer surveillance is said to take place. And for that, I'm going to come into precisely these types of examples and consider and say, actually, it's more akin to a telephone call made from one state into another state that causes injury. And I'll come to examine those examples. But that's a separate question from where all of the causal acts have to take place. Yeah. And it's in relation to that this is an important passage, because what it says clearly is that on the International Law Commission's view and the view of the authors of the commentary, there are two requirements that have to be fulfilled. The act has to occur in the territory and the presence requirement, both of which are, if you like, a belt and braces. That's probably the best way to refer to them. They're belt and braces ways of ensuring that acts take place in the jurisdiction. Now, it so happens that both the belts and braces have been incorporated into Section 5. That's my construction point, as supported by Article 11. But in any case, even if it's one rather than the other, you still have all of the acts having to occur in the jurisdiction. And if I can take you then finally on the UN Convention to Fox and Webb.
How much help do we get from a 2004 convention and commentary on that in interpreting a 1978 act?
My Lord, in my submission, we get a lot of, it's very helpful because it shows a consistent approach of international law in the EXI, in the UN Convention, as I shall come on to explain in the US cases. There is a constant thread running throughout all of these international acts, treaties, foreign domestic court decisions. All causal acts have to occur in the territory. So finally on the UN Convention, it's the Fox and Webb quote, which is at page 8 of the judge's document. At the bottom of the page, the jurisdictional conditions of the occurrence of the act and presence of the author of the act within the territory of the formed state are discussed later in this chapter. And this is the key passage. It is to be noted that the possibility of such an exception, removing immunity when such conduct occurred outside the territory of the formed state, was never discussed by the IRC. And this is, and let me just emphasize this, and would certainly have been treated as out of order. Their discussions and UN Convention only address the application of immunity in respect to proceedings where the formed state exercises undisputed jurisdiction, that is, in respect of acts performed within its territory. Let me pause there. Fox and Webb say that the drafters would certainly have considered any notion causal act outside would be out of order. And in my submission, the UN Convention provides further support to the construction I've given. Finally, on Fox and Webb, if we can, it continues on to say, in this formulation, the formulation of the UN Convention I've taken you to, the required twofold jurisdictional connection is derived from the same required connection in the personal injuries exception in XC Article 11. Lord Justice Mayles, that goes directly to your point, which in turn derives the requirement from the general rules of private international law as set out in the 1971 Hague Convention on Recognition and Enforcement of Judgments. And I'd emphasize, this jurisdictional connection is stricter, and this is a key point for when we get to the tort case, the gateway cases that the judge relied on. This jurisdictional connection is stricter than that required as the basis of jurisdiction for claims in tort recognised in the Brussels Convention, which is given effect in English law. The English rules relating to service out provide for service in respect of a claim in tort where damage was sustained in the jurisdiction or damage resulted from an act committed in the jurisdiction. They go on to say, the learned authors, this first condition that the act causing the damages to be performed within the territory of the forum state is broadly applied by all jurisdictions in which a restrictive doctrine of immunity is accepted, such as in Section 5 and in the legislation of the common law countries which introduced legislation following the UK model. So, my Lord Justice Mayles, that goes on to say in terms that it traces the lineage and it explains that it comes from the 71 Convention, then was implemented in XE, then was implemented in the State Immunity Act, implemented in the UN Convention, and it's been adopted by countries around the world. And so the judge was wrong then in my submission in his judgment at paragraphs 107 to 109 to have employed as support for his construction of Section 5 the approach given to the tort gateway in England and Wales in our Praxis Direction 6B 319B.
Sorry, just for my note, could you give me the reference again?
Yes, of course. It's paras 107 to 109,
Thank you.
which is core bundle, tab 8,
Yes, got it.
PDF page 115.
I remember this, thank you. Yes.
So first, so there's two points in support of why the judge is wrong here. First, as Fox and Webb have explained, there is a stricter jurisdictional test embodied in Section 5 compared to that in the tort gateway for permission to serve out. And so this makes the gateway approach of substantial and efficacious act simply not applicable, or appropriate rather, in relation to the State Immunity Act. And second, with respect, the judge was in my submission wrong to have used the construction given to a practice direction in the CPR, which applies only, in fact, to two parts of the United Kingdom, so as to give meaning to a term in a UK-wide legislation on a different issue with a different purpose, relating in particular to state immunity, which, as I've shown you, the Supreme Court has said is an area of considerable sensitivity. Let me move straight away then to the US cases which support my construction, and this is my fifth overarching point on construction. My lady, my lords, the US FISA, or FSIA, Foreign Sovereign Immunity Act, was enacted in 1976, 2 years before our act. So it's no surprise that our courts have relied heavily at times on US case law when construing similar provisions of the State Immunity Act. If I could take you first to the Servas case, Servas versus Refidine Bank of the Supreme Court. Servas, let me just tell you, of course I'm sure you're aware of the case, it was about the meaning to be given to the phrase in Section 13(4) that removes immunity from execution for state-owned property. And the phrase is, which is for the time being in use or intended for use for commercial purposes. That's what the Supreme Court had to construe, give a construction of. If I could take you first to Lord Clark's statement at judgment at paras 22 and 23. Lord Clark gave the judgment on behalf of the court. You'll see it on page 9 of the judge's document. And Lord Clark says, it was suggested on behalf of Servas that there is a relevant distinction for present purposes. In fact, if I could just ask you to read that first paragraph 22, please.
So what's the point from here?
Yes,
That
so
we
paragraph-
could use the definition in FISA to inform the interpretation.
Yes, but it goes on to say in 23, the American cases draw the same distinction between the source of property and its use. The immunity of states from execution is governed by the FISA, which was the leading precursor of the Act. And then it goes on to say what Section 1610 says. And you'll see there that actually, I mean, the phrase in the UK statute, as I've said, is which Section 13.4, which is for the time being in use or intended for use for commercial purposes. But here, the language is not identical. It simply says used for a commercial activity. And yet Lord Clark went on to refer in detail to US case law when construing the analogous FISA provisions, which in his words is the leading precursor of the Act. Lord Clark goes on to say, and you'll see this over the page 10 of the judge's document, having examined the US cases on this different language, commercial activity in use or intended for use for commercial purposes, Lord Clark says, those decisions are strong persuasive authority and given a close relationship, he doesn't say exact language, close relationship between the language of Section 13.4 and Section 1610 of FISA seem to me to support the meaning to be given. So let's then turn to look at the first of our US cases. This is Doe versus Ethiopia, or when it's de-anonymized, it's referred to as Kidane versus Ethiopia. This case involved exactly the same type of software that's alleged to have been used in this case. It's the FinSpy software. If your lordship wants to find it, it's in Authorities Bundle 9, tab 122, page 3276. And you'll see there, under opinion, so I'm just turning it up myself. Yes, have you got it? Yes?
Yes.
I'm grateful. So you'll see there, under opinion, it says, it explains the plaintiff alleged he was tricked into downloading a computer program. You see there's tricked into downloading a computer program which allegedly enabled Ethiopia to spy on him from abroad. And the district court upheld Ethiopia's immunity under the FISA. The plaintiff then appealed to the US Federal Court of Appeals. You'll see under the heading background, which is a bit further down that page. And in fact, I see that this has been helpfully included by my learned junior on page 10 of the judge's notes, which may make it easier. It says, as alleged in the complaint, in late 2012, early 2013, Kidane opened an email, attachment to an email he received from an acquaintance, The email had been forwarded and was allegedly sent originally by or on behalf of Ethiopia, and then take you to the internal page, the bottom of that page marked HN, the next quote, which says, the FISA is the sole basis for obtaining jurisdiction over a foreign state. Unless an exception applies, a foreign state shall be immune from the jurisdiction of the courts. So it follows the same approach of our courts, Section 1 and then the exceptions. One of those exceptions, the court went on to say, is the non-commercial tort exception. And here's the language of FISA, which we have to compare to Section 5. It abrogates immunity from an action involving personal injury occurring in the United States and caused by the tortious act of a foreign state while acting within the scope of office or employment. So you'll see there, my lady and my lords, that there's an express requirement in FISA that the personal injury occurs in the US, but the provision is silent on where the causal act must take place. And so in some senses, the personal injury exception, certainly in relation to acts, at first glance may appear broader than Section 5 in relation to where the causal acts must take place. And yet, despite this, or perhaps more accurately because of this, the interpretation that the courts, US courts, have given to the personal injury provision of FISA is that both the causal act and the injury, that is the entire tort, must occur within the US. And you'll see this over the page and in the following quote at paragraph 22 on page 10 of the judge's document. The phrase occurring in the United States is no mere surplusage. The entire tort, including not only the injury, but also the act precipitating that injury, must occur in the United States. Now, let me pause here. I'm not inviting the court to apply the entire tort approach or doctrine in relation to Section 5. That is contrary to what the judge said, not my submission. But what I do rely upon here, my lady and lords, is the approach taken by the US court that each causal act must occur within the United States. The need for the act to have been committed in the territory of the forum is so fundamental that the US courts have strained the language in my submission to accommodate it. The court continued on. It referred then to two cases on which Cadane relies, which supported their view that acts occurring abroad should be allowed to fall within the scope of the exception. And these are the Liu versus China and Letelier versus Republic of Chile case. And this is what the judge said, the court said. The two cases on which Cadane relies are easily distinguished. In Liu, two gunmen allegedly assassinated a man in California. In Letelier, Chilean agents, government agents, allegedly constructed, planted and detonated a car bomb in Washington. In both, the courts determined they had jurisdiction under FISA's non-commercial exception to hear the victim's survivors' claims. Both involved acts occurring in the United States, and this is the key passage, that without reference to any action undertaken abroad. Ethiopia's, it continues, digital espionage is of a different character. Without the software's initial dispatch or an intent to spy, I'm not sure I'd rely on that.
No, I don't think, no.
Integral aspects of the final tort, which lay solely abroad, Ethiopia could not have intruded upon Cadane's seclusion. And it continues, the tort Cadane alleges thus did not occur entirely in the United States. It is a transnational tort over which we lack subject matter jurisdiction. Finally, on this point on the US cases, let me take you to Democratic National Commission versus Russia.
Just pausing there, that passage indicates the tort complained of was an intrusion into seclusion. It was a privacy tort. It'd be helpful to have a reference at some stage to where the judgment identifies the nature of the US wrong that was complained of.
Yes, yes, of course. In fact, they said we'll certainly supply that, my lord, because in fact they said that the act occurred abroad. That's precisely what they found in Canada, and I'll come to that. That's on ground one. Democratic National Commission versus Russia. Here, the reference here is Authorities Bundle 9, PDF page 692. And once again, we have the relevant quotes here. It's page 11 of the judge's document. My lady, my lords, in this second authority, the US Democratic National Committee alleged that the Russian government had hacked the DNC's computer network in relation to the 2016 presidential election and removed and disseminated large numbers of documents, primarily through WikiLeaks. We pick up the facts which are set out in the judgment, and you see this on page 11, paragraph 23. If I could just ask you to read that, that provides the background. Thank you. And so then we move over to Judge Kurtel at pages 427 and 8, internal document 3298 of the bundle. And this is quite an important passage. It says, the DNC alleges that a major and a lieutenant colonel of the Russian military supervised GRU officers, that's I think the cyber espionage section of the government, and it goes on to say that they accessed, developed, customized and monitored the ex-agent malware used on the DNC's computer network. They placed the ex-agent malware on the DNC computer network and monitored the malware after the hack.
So just reading through, I think, to the bottom of this paragraph, what was wrong with the judge's approach to these cases when he said, this is all got to be read in the context of the entire tort theory that we see highlighted in this paragraph, which we don't have.
No, we don't, my lady. But the point is that, as I've shown you from the statutory language of the FISA, the only thing that was required to occur in terms under the FISA was the injury. Where the act occurred was not specified. And despite that, the court went on to require that the acts must all take place, the causal acts, in the US. And that's the basis for them saying that the entire tort has to occur within the US. And the judge in this case, DNC versus Russia, goes on to say in this quote, and you see there it's the last penultimate sentence, because the theft, this is the digital theft, was planned and executed from computers in Russia. This goes to the point Lord Justice Warby raised. It is plain that the entire tort, i.e. the act and the injury, but really the act here, did not take place in the United States. The DNC has cited no similar case where the non-commercial tort exception was applied when a portion of the conduct of the foreign government occurred outside the United States. So, in summary, then, the US cases support the construction all causal acts must take place in the UK, and that no related act that takes place, causal act that takes place abroad, can engage the exception. Indeed, we see from the first instance decision of the court in Doe versus Ethiopia, Judge Moss, I had taken you to the Court of Appeals, but Judge Moss, he makes an important statement here in relation to what my Lord Justice Mayles raised with me, which is the continuous thread, if you like, running through all of this. And you see this on page 11 of the judge's document. Third and finally, the legislative history, page 11, Judge Moss, towards the last quote on the page. Third and finally, the legislative history of the non-commercial tort exception provides additional support for the conclusion that Congress did not intend to reach torts precipitated by the actions of tortfeasors outside the US. One of the primary goals of the FISA, to bring US rules of foreign sovereign immunity in line with the practices of other nations, and in particular to subject foreign states that commit torts in the US to the same rules of immunity applied against the US abroad. And then the key passage continues halfway down the column over the page on page 12 of the judge's document. This same legislative history also reflects an understanding of the European model, Article 11 I've taken you to, that Congress sought to mirror. Now, I'll just pause there. Congress, like the UK State Immunity Act, adopted, dare I say, a more elegant, briefer approach, or a more brevity-oriented approach to the point than the European Convention did. But here you have the judge saying that the same legislative history reflects an understanding of the European model that Congress sought to mirror. And just as in the UK we don't have the presence requirement, nor do they have the presence requirement in the US. And yet, the important point is that the causal acts have to occur in the jurisdiction. In particular, the legislative record included a copy of the European Convention on State Immunity, which was scheduled to come into force roughly a week later. When asked at a hearing whether there was any inconsistency between that new convention and the bill that became the FISA, the legal advisor to the State Department answered no, with the sole qualification that it went further regarding the execution of judgments against foreign states.
But the US position is very different from the Article 11 EXE position, isn't it? Because the US has the entire tort theory, needing both act and damage within the United States, and the European Convention does not have that. So they might have been trying to implement it, but the way they've interpreted the US statute has resulted in a very different approach.
Yes, my lord, but in relation to acts, which is what we're concerned with today, you've seen that there's been a straining, if I can use that phrase again, straining by the courts to construe acts as having to occur within the jurisdiction, which is, after all, what a key part of what the European Convention was about, because it required both the facts occasioning injury to occur in the territory of the forum and also the presence requirement, the belt and braces approach. And so in relation to that point...
If the legal advisor to the State Department had known how the US courts were going to implement the bill as drafted, his answer would have been yes, not no.
Well, in the sense that the European Convention didn't say in terms anything about where the injury was to take place, which is really what we're discussing. Because, of course, I think Your Lordship will see the point in relation to acts, but in relation to where the injury happens, which is what the entire tort doctrine is about, there the European Convention was silent on it, and that has been transformed differently into the well, maybe not even differently, but it could be consistent depending on the way one approaches what the Article 11 says. I mean, the fact is that Article 11, as I say, was silent in effect on it. So it's not an apparent inconsistency, if I can put it that way. The fact that Article 11 doesn't specify where the injury occurs, but...
Well, but you've disavowed the entire tort theory as an interpretation of Section 5.
Well, I don't need to go that far, my lord. That's the point. I don't need to go as far as that in order to prevail on my construction.
Okay, thank you.
I'm grateful. Now, if I could take you to what the judge says in relation to the US cases. This is at Core Bundle tab 8, PDF page 117 or paragraph 113. you'll see the judge says,
But it's World War I. He says it's based on different statutory wording and upon Pfizer's distinct legislative history.
Yes, my lady. He says, I remain of the view that caution must always be exercised in placing reliance upon decisions of foreign courts in relation to different statutes. Well, let me just pause there. As I've taken you to Lord Clark in Servas, he says the exact opposite. He says, in relation to construing the terms of the the State Immunity Act, an important precursor is the Pfizer, and it provides, I quote, persuasive authority, where there's similar language. Now, we'll come to the judge's point on language. Well, he referred to key differences between the language of Section 5 and 1605A. But the only difference is that only two differences, that it refers to a tortious act or omission in Section 1605, while the State Immunity Act refers to an act or omission. But with respect, this takes the judge's analysis nowhere. On any view, the Pfizer and State Immunity Act are both referring to tortious acts. That takes the judge nowhere. And the point is, in relation to the entire tort doctrine, as I've discussed with Lord Justice Mayles, that doesn't detract from the construction of Section 5, but it only supports it, because when faced with the question of whether all causal acts should take place within the US or whether some may take place abroad, the US courts chose to ensure they did not exercise jurisdiction over foreign states' causal acts committed abroad. In any case, let me recall briefly from Servas that the Pfizer provisions in that case were also not identical. In fact, I didn't take the court to this, but there were some specific conditions that had to be satisfied before the commercial exception could be invoked against foreign state property in the Pfizer that simply didn't exist in the State Immunity Act. But more importantly, also the language in the Pfizer was not identical to the corresponding provision of Section 13.4, as I've shown you, when it referred to simply Pfizer used for a commercial activity, while for us it was in use or intended for use for commercial purposes. Let me round out my points on construction, my lady and lords, if I may.
So this is rounding up on ground 2.
Yes, exactly. I'll deal briefly with the ex parte decisions in Heiser and Ben Raphael, hopefully taking us up nicely to lunch. Having left the American cases, I could do with a comfort break, but I think we'll prevail. So, as already noted, the court has issued the practice direction. I won't take you through that. But in 2001, the Citation of Authorities practice direction of the Court of Appeal. But in more substantive terms, the subsequent inter partes judgment in Heiser rejected the argument, and that was quoted by the judge in the subsequent inter partes decision of Heiser on conspiracy to commit terrorism and composite acts. I mean, essentially, the argument, and let me just give you the reference. This is in the judgment at just paragraph 101. Thank you. It's paragraph 101 of the judgment, where the judge relies on the Heiser ex parte decision. Sorry, is that right? What is the line? Heiser ex parte? Just while my learned junior is finding it, the point is that in the Heiser ex parte decision in which I appeared before Mr. Justice Singh, as he then was, I made the rather, I think I'd say, ambitious argument, which was that conspiracy to commit terrorism and composite acts, that the effect of those acts, given that it's terrorism, should be wrapped up in the concept of act itself, so that where a terrorist act occurs from one territory into another, then that should be considered as an act within the state where the terrorist attack took place. It's in paragraph 98 that it's quoted from the ex parte judgment. And let me just give you the reference to the Heiser inter partes judgment, which is in the Authorities Bundle 6, PDF page 972. You'll see that the judge takes a different approach to that issue as quoted in paragraph 98 in our case. And when the judge quotes paragraph 99 from Mrs. Justice Whipple, as she was then, once again, the judge has unfortunately misunderstood what's happened. The US court ruling that Judge Whipple quotes from, that is a quote from the US court ruling, and you see that when it says that noted that the US courts had concluded that. And so that was a US court ruling. The judge didn't fully appreciate that this was dealing with the specific terrorism exception to personal immunity. Now, if I can take you briefly to the Heiser case on this, the inter partes decision, at paragraph 97, which is Authorities Bundle 6, PDF page 957. It's in the quote. Sorry, it's in the judge's document.
Lost me. It was my fault. You were going to refer to the two ex parte decisions, Heiser and Bon Raphael. Now you want to go to Heiser
Inter partes, exactly.
Right, and
Which is a judge's document 12, page 12. And you'll see there Heiser versus Iran. This is the inter partes. Mr. Justice Stewart, 97. And he makes clear that actually there is a, as it happens, the expert was called Stewart as well in that case. But it makes clear that this was talking about the section 1605 capital A of FISA, which was the specific terrorism exception that was enacted specifically by US Congress in 1996 because the regular personal injury exception was constantly batting away terrorist cases where there was an act occurring outside the jurisdiction, where there were acts occurring outside the United States. And you see this where it says in 98, a number of decisions in the US courts had ruled that the non-commercial tort exception required both the tortious act and the injury to have occurred in the US. Most actions claiming damages in respect to terrorist attacks failed on this basis. And then it goes on to say, it refers to Professor Stewart's report, distinguished professor at Georgetown, and then he goes on to summarize over the page on page 13 of the judge's document, paragraph 100 of the Heiser judgment. In summary, the difference between Section 5 of the 78 Act and the terrorist exception is the words of Section 5 require the act or omission causing injury to have been an act in the United Kingdom. The terrorist exception requires only that the plaintiff's victims are US nationals. The relevant acts are alleged acts of terrorism as provided for, so as long as they're a US national and the state committing the act is on the list of state sponsors of terrorism, then that's sufficient to engage this specific terrorism exception. And that's the exception that Mrs. Justice Whipple was referring to when she was quoting that passage from the US court. So, conclusion on construction in brief. My lady, my lords, to allow the judge's construction of Section 5 to stand in this case would be to drive a coach and horses through state immunity and its key underlying principles of comity and the equality of states. There is also a point here on reciprocity. The equality of states embodied in state immunity requires each state to give effect to comity, especially, I would submit, in relation to a foreign government's acts committed within its own territory, in order to ensure that our own government is accorded the same respect. This is not without significance in the area of alleged computer surveillance. The judge's decision in this case is novel. It's the first time that our courts have extended the scope of Section 5 to include a foreign state's acts committed abroad. Indeed, so far as I'm aware, and the respondents have not told us otherwise, it is the first time that any common law court anywhere in the world has extended their normal statutory personal injury exception as the judge has done in this case. With respect, the judge was wrong to adopt this construction of Section 5, and the better construction, for the reasons I've given, is that Section 5 is engaged when all causal acts are committed in the UK. The appeal on this basis alone should respectfully be allowed. Lady?
Can I just ask if this is such a novel and unprecedented decision, as you suggest, has it attracted academic commentary or case notes in any of the leading journals?
There's been a few blogs, I think, my lord. I mean, you know,
Blogs are less helpful,
it's
really.
unfortunately international law scholarship. Don't get me started on that. There's been a decline. It's all moved to blogs now. But the answer is not that I know, my lord. But I will certainly.
All the parties check, please.
Yes,
just
of
to see
course.
if there is anything that's presentable.
Yes,
Sharing, that would be very interesting.
I share your sensibilities, my lady.
Thank you. Thank you very much. That neatly wraps up ground 2. Grounds 1 and 3 and Article 6, are you on course to finish comfortably by 4:15 or so?
Yes, my lady. In fact, we have a, yes, I am. Yes, I'm grateful.
All right then, 2:05. Thank you very much.
Court rise in April.